Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? The United States Supreme Court's recent decision to end the Chevron doctrine in the Loper Bright case exposed a governmental fault line, which may have far-reaching implications for many entrenched U.S. federal agency regulations that have existed for decades, and consequently, for employers. In SEC versus Jarkesy, the court held that certain SEC adjudications must take place in court because defendants are entitled to a jury trial. The impact of the Loper Bright and Jarkesy decisions could be widely felt, including in increased immigration litigation and challenges. On this episode of our podcast series, Workplace Law After Loper, we discuss the ramifications of these decisions for immigration compliance. Today's hosts are Michael Nefak, Office Managing Principal in the Washington, D.C. region, and Amy Peck, Principal in the Omaha office of Jackson Lewis, and co-leaders of the Immigration Group. Michael and Amy, the question on everyone's mind today is, how do the U.S. Supreme Court's decisions in Loper Bright and Jarkesy affect immigration proceedings, and how does that impact my business?
Well, I am thrilled to be here with my good friend Amy Peck. We are going to talk about the sea change in administrative law and with Chevron being overturned and some other Supreme Court cases. But the news really has been that Chevron is dead. Chevron, which has been the law since 1984, and really was a bedrock in how administrative agencies operated and their relationship with federal courts. It was overturned by the Supreme Court. And let's just back up a little and say, what did Chevron do? So Chevron said that when you're looking at an any administrative agencies, that you look at the plain language of the statute. Is the agency vested with the authority to do whatever it is? And if it is, then that's the end of the analysis. If it's ambiguous, and in the world of immigration particularly, so much of what we do is really ambiguous, that there the court has to determine whether the agency's decision was arbitrary and capricious. And if it wasn't, and it was reasonable, that's the end of the analysis. The courts will defer to agencies and let the agency's determination rule. And that really gave the agencies wide discretion to make very far-reaching decisions, even where the statute or regulations didn't say that. And it wasn't the only way that a court could come out. So with Loper Bright, the Supreme Court said that we're no longer going to do that. That doesn't take into account the APA requirements. It potentially is unconstitutional. There are a number of reasons that Chevron is unworkable. And frankly, it hadn't been applied in the immigration context directly since 2016. But with Loper Bright, it became clear that no longer will courts defer to agencies, which potentially gives individuals and companies much wider range to go into court and challenge an agency's determination, whether it's the definition of an aggravated felony, what is a specialty occupation in the H-1B, what is a particular social group in the asylum context. In all of those areas, the USCIS, ICE, DHS, Department of Justice fill in those gaps with what they view as a reasonable interpretation. The courts have deferred. That's no longer the case. And I think it potentially opens up a significant litigation and challenges where we can roll back some of what the agency is doing for good and for bad. Interesting thing is, in addition to Loper Bright, at that same time, there was another decision, Jarkesy, which significantly impacts or potentially impacts the immigration litigation world as well. And I want to just kick it over to Amy to give a little bit of what Jarkesy did and what those impacts are.
Well, hello, everybody. It's my pleasure to be here today with, as Michael said, my good friend, Michael. It has been a great time to be alive in this space because the sea shift in these cases. And, the agencies really have had a lot of power post Chevron. And like Michael said, the courts kind of deferred to the agencies, and agencies said, yes, please. We like this. We love this Supreme Court ruling, and we're going to take this as far as we can. And some would argue too far. And so when Loper Bright came along, there was a real, I'd say, relief among some people. And a lot of people thought, well, it's about time. Well, Jarkesy is another in this line of cases. This was decided June 27th, 2024. This is also a Supreme Court case. It's the SEC versus Jarkesy, Jarkesy. And this was a case when the SEC, Security and Exchange Commission, was seeking civil penalties from defendants for securities fraud. And the administrative tribunal was finding for fraud, finding for the SEC. And this went up to the Supreme Court. And the Supreme Court said, wait a minute, the Seventh Amendment requires these types of actions. You're trying the defendant for fraud in an administrative tribunal. And Seventh Amendment says, not so fast. You have to bring this action in a court of law where the defendant is entitled to a trial by jury. And this was a 6-3 decision, and it ended essentially the SEC's long-running use of in-house tribunals led by ALJs, administrative law judges, to adjudicate fraud actions. And again, this was one where, lawyers are saying, okay, now what? Because there are a lot of administrative tribunals out there, the EEOC, for example, OCAHO, which is one that a lot of people don't know about, but that stands for the Office of Chief Administrative Hearing Officer. And that OCAHO hears cases under 8 U.S.C. 1324A, which are I-9 violations, I-9 fines. Also 8 U.S.C. 1324B, which are Immigrant and Employee Rights Division actions that's brought by the Department of Justice, or individual actions that are brought under 8 U.S.C. 1324B that are not properly before the EEOC. And OCAHO is an administrative body. They're ALJs that cover OCAHO. So all of a sudden, things are looking very interesting with these administrative bodies, including the EEOC, under Jarkesy and under Loper Bright. So let me talk about a couple areas where we've seen some real movement. There have been some recent cases in the EEOC, but I'm going to talk about the 8 U.S.C. 1324A, which are the I-9 decision with Walmart, and 8 U.S.C. 1324B, which is the SpaceX decision. Let's start with the Walmart decision. Let me set this up a little bit. Walmart was found to have violated 8 U.S.C. 1324A and was fined for I-9 violations. And Walmart disagreed with this. Walmart said, we don't think that you are properly assessing these fines. We don't think that what you said we did wrong. We don't think we did that. And Immigration Customs Enforcement, Department of Homeland Security said, nonetheless, we're going to fine you. Walmart filed in the district court in Georgia and made some arguments that furthered Jarkesy and Loper Bright, and basically said that OCAHO, which is this administrative body, those administrative law judges are unlawfully shielded from removal by the president. And that makes them unaccountable to the executive. So the president must have removal power under the Constitution to keep officers accountable, as well as to promote democratic accountability so the public can judge the president's efforts. And Walmart said that is not the case with OCAHO. And these certain principal officers within OCAHO have double insulation from removal under Article 2. And basically, the district court agreed and said that the ALJ's broad power to assess these fines and penalties against private parties on behalf of the government requires supervision by the president. And basically, they granted an injunction in favor of Walmart, saying that OCO has unconstitutional authority for ALJs to act. And this interpretation, of course, has not been accepted by OCO. OCO is like, who, us, worry? We don't recognize that decision. And it was not an injunction for all the cases. It was an injunction for the Walmart case. And it is on appeal. But basically, this and a number of other cases will probably end up in front of the Supreme Court again.
And Amy, now we have, on top of Jarkesy, you have Loper Bright. And I would imagine that in the context of all this, you're now looking at a court being able to say, and I don't have to defer to your interpretation of this. I don't have to defer to your scheme. And so it just adds to, from a pro-plaintiff standpoint, it gets to, this is now another opportunity where we can potentially push back at, the agency's determination that based on X, whatever it is, we owe all of these fines, when in fact the process that you're using isn't grounded in the statute, and the tribunal that you're working is not affording the claimants their due process.
That's
and
right.
So I think that this really is something where now, in the past, so many of our clients were just saying, you know what, we'll just try to settle it, we'll write a check, and we'll move on. The government has now started to up the ante, and we're seeing fines potentially in the millions of dollars, and not willing to settle what we would think is a more reasonable amount. And at the same time, you've got these court proceedings or these court determinations that hopefully will let courts take a much, more clear-eyed view and hopefully sustain some of these challenges.
Yeah. And that leads right over to the SpaceX case. And I think the overarching theme is the courts are saying, look, administrative agencies, you are going too far. These fines are really high. The agencies have a pretty big opinion of themselves coming in and, in potentially an unfair tribunal, which I'm sure they would dispute, right? The tribunals themselves would dispute that. But the courts are saying, look, these decisions within these administrative tribunals can have a huge impact on companies and individuals, and it should be heard in an Article 3 court, not an administrative tribunal. So in comes the SpaceX decision. So the SpaceX decision, this was in Fifth Circuit, Texas. And basically, SpaceX got sideways under 8 U.S.C. 1324B, allegedly, and that is within the purview of the Immigrant and Employee Rights Division. And the Immigrant and Employee Rights Division is part of the Department of Justice, and they are charged with administering 1324B, which is citizenship discrimination, nationality description for employers of fewer than 15 employees. The rest of those go to EEOC. Documentation discrimination, such as if you are requiring permanent residents to produce their green card during the I-9 process, and then retaliation in the hiring process. So basically, it's a narrow scope, but it's all related to the hiring and recruitment process tied to I-9s. Well, the IER contended that SpaceX placed a bunch of ads that forgot to include refugees and asylees. And, why is that important? Because U.S. citizens or U.S. nationals are born in U.S. protectorates. So U.S. citizens or nationals, permanent residents, asylees, and refugees are protected individuals under 1324B. Folks on work visas are not protected, but the class that I just mentioned is protected. And IER contended that SpaceX placed ads for U.S. citizens only or U.S. citizens and permanent residents and forgot about asylees and refugees, and that this was citizenship discrimination and that SpaceX owed them millions of dollars. And SpaceX said that's an unreasonable amount. And they went back and forth, and eventually SpaceX filed litigation in the Fifth Circuit and forwarded a couple different theories, but one of them was that the OCAHO was designed to bypass the Attorney General. And if you look at the statute, that's in fact what happened, and that this is unconstitutional. The Attorney General must be able to review 1324B decisions, and basically that this was unconstitutional. The government anticipated this argument and tried to change the regulations, and in fact went through a rulemaking process to change the regulations. But the statute makes clear that the regulations are now in conflict with the statute. So the court wasn't persuaded. The court's like, this is not lining up. And they found in favor of SpaceX. So this is also a case that found OCAHO as a body with respect to 1324B cases is unconstitutional. Now, the IER is not having it. They are saying, what? Nothing to see here. Nothing to see here. Proceed as usual. But this gives companies who have litigation with the IER, quite frankly, a lot of leverage. Now, whether the IER recognizes that is another matter. Again, they're pretending that these cases don't exist, but this is real. And the SpaceX litigation and the arguments that they forwarded are quite strong, just by plain statutory interpretation. So it's a fun time to be alive, Michael.
It is. And I think that similar to Walmart, there's an opening now to also challenge in light of Loper Bright, and to make those points that, in fact, on a substantive basis, what IER is doing, and also getting into sometimes they view their jurisdiction as broader than maybe the statute allows, especially when they're doing their own independent investigations. I think that there is potential to start raising those Loper Bright arguments and saying to courts, you don't have to defer to what the agency is doing. There's really not an interpretation that fits within what the law allows, and to start narrowing the scope of, how far back should IER be able to look to see if there were violations, especially when they're making these systemic allegations that are based on sort of you didn't maybe include asylees, and therefore we're going to ping you and fine you for each job application that was out there or job note posting, even though there's no proof that anybody was specifically not selected or chose not to apply because of the way that the job posting was worded. So I think that there's multiple things here. OCAHO on its own does not have the authority under Jarkesy, or substantively what the agency's doing. There's really no deference there, and it's beyond what the statute allows.
Yeah, I think you're exactly right. The IER does not want us questioning their authority, and Department of Homeland Security, that's kind of separate because immigration is traditionally exclusive function of the federal government and the sovereign. But the IR cases, this is something where if you do have one, you need to be digging into these issues because they are very powerful. And it's been a long time since companies have had leverage against the IER.
Yeah, and we're already seeing, again, clients that in the past would have just said, let's just sign away and settle this and make it go away, are now starting to say, wait a minute, can we challenge this? And the answer, is yes, we can challenge it. We don't know how this is all going to play out, but in the right set of circumstances, I think it does give you leverage to push back and not just take what the government is offering. The flip side, of course, of some of this is that there are things that the government does that USCIS has put forward and what DHS has put out, sort of implementing the statute in a way that is favorable for practitioners and employers. And, some of the things that come to mind are the OPT and STEM OPT rules. These are rules that allow an individual who may have graduated from university to continue in student status under optional practical training and STEM OPT so that they can continue to work for companies for 1 year, and then if they're STEM OPT for another 2 years. Well, the government issued regulations and rules that broadly interpreted what's not in the statute to allow those individuals to continue to have work authorization and remain lawfully in the United States. There have been groups that have been trying to challenge some of those rules. And because it's an interpretation that is reasonable, those have not been successful. Now, with the end of Chevron and under Loper Bright, it remains to be seen if there's going to be ways, and you're going to start seeing challenges to some of these kinds of more favorable government interpretations and whether there's going to be pushback. I think also, of H-4 work authorization, and the big one is DACA, which has been challenged in litigation for years. But certainly, the end of Chevron deference isn't, I wouldn't think, helpful to the government's position that we have the authority to, interpret. Now, it's not as simple as that. There's arguments to be made, et cetera. But big picture wise, I think Loper Bright makes some of those administrative interpretations that are favorable more difficult.
Well said.
Some of the other areas where we'll just have to wait and see what happens is, with outstanding individuals, EB-1 petitions. The government did something that was sort of interesting. There was a very clear defined line of what you needed to meet to show that you were eligible under the EB-1, employment-based first preference category. There were sort of 10 factors. And if you could hit 3 of them, you could make the case and hopefully get to the petition, assuming that the government bought what you were saying, those would be approved. The government has now glommed on a new final merits determination that they sort of made up and did in a policy handbook that isn't in the regulations, isn't in the statute, and has made it more difficult for these outstanding, whether it's an academic or a business person or what have you, to meet the requirements. And the government has been denying more of those cases. Well, post Loper Bright, there's no deference to that interpretation. And I think we can argue that that was just made up by USCIS. And, to the extent that it's just sort of duplicating what is already in those 10 factors, it's not even a reasonable or persuasive interpretation. So I think there is another example of where we've got more leeway to push back at the government. So this is all really new. We're just now seeing the litigation, and a lot of this is not yet getting to litigation, but we're seeing arguments that we're making on behalf of our clients to the government. And there are instances where the government's saying, we don't need this to go to court. We'll settle on a more advantageous term. We've had in the I-9 cases, we've had some situations where the government has said, we won't issue a fine. We'll issue a warning notice and let's move on from this. So, not always the case. And there are instances, Amy mentioned, that IER is really looking at this like they're just marching forward and saying that these district court decisions are not nationwide, they're not affecting them, and they're not going to really impact the way that they're going to be treating these individual cases. But at some point, this is going to inevitably reach the Supreme Court, and then we will see how both Loper Bright and Jarkesy, what the full ramifications are.
And we're looking forward to it because it's a lot of fun to tell the government that we don't like their made-up policy and we don't like their made-up interpretation of the statute, and see what they say. So it's a great time to be alive.
Well, thanks, Amy. I'm glad we had a chance to go through this. I'd love to do another one in a year or 6 months when we start to see how these things really do play out, and it is an exciting time. Thanks, everybody.
Thank you very much.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, This material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.